landmark ruling from the United States Supreme Court today tied to the Voting Rights Act.
This decision could not only impact Texas politics, but politics across the country.
The Supreme Court has ruled to limit the Voting Rights Act.
An unexpected midnight emergency docket drop at the highest levels of American judicial power has just detonated a constitutional landmine, instantly rewriting the rules of engagement for federal elections across the country. Behind closed doors and without warning, a fierce war over political geography reached a boiling point, culminating in a high-stakes showdown that completely sidelined lower federal courts and upended traditional voting frameworks. This was not just another routine disagreement between rival political factions. It was a total collision between state sovereignty and federal judicial oversight that fundamentally shattered established legal norms. At the center of this intense firestorm is a high-powered legal strategy deployed by the state of Alabama, which took the unprecedented step of bypassing standard appellate procedures entirely to demand immediate intervention from the United States Supreme Court.
Questions are growing about what it will mean for the future of voting in America.
To understand the true magnitude of what just unfolded, we have to look past the dense legal jargon and examine the raw mechanics of power, judicial defiance, and a multi-year chess match that has transformed a regional redistricting dispute into a nationwide referendum on the future of American voting rights. The origins of this constitutional crisis trace back directly to the aftermath of the 2020 decennial census, a mandatory nationwide population count that forced state legislatures across the country to redraw their political boundaries to account for sweeping demographic shifts. In the state of Alabama, the Republican-controlled state legislature adopted a congressional map that quickly became the target of intense legal challenges from various political and civil rights organizations. Opponents, represented by prominent plaintiffs, including organized groups of black voters and advocacy coalitions, filed lawsuits arguing that the newly minted map unlawfully diluted minority voting power in violation of Section 2 of the Voting Rights Act. A three-judge federal district court panel agreed with those challengers, issuing a sweeping injunction that blocked the state's map and ruled that Alabama was legally required to construct a new layout featuring an additional majority black district or an equivalent opportunity district to ensure fair representation for minority populations. That initial ruling set off a volatile chain reaction that eventually landed at the Supreme Court in the landmark case known as Allen v. Milligan. In that major decision, the High Court affirmed the lower court's injunction, holding that Alabama's original congressional plan indeed violated federal voting protections by splitting minority populations across multiple jurisdictions, thereby preventing them from electing candidates of their choice. For a brief moment in time, it appeared that the intense legal battle had reached a definitive conclusion, with the federal judiciary firmly dictating the boundaries of acceptable map-making and enforcing strict compliance across southern states. However, rather than finally settling the underlying issue, that ruling instead opened up a massive new front in the sprawling war over election law. Following the Milligan precedent, the Supreme Court issued subsequent clarifications and refined its legal doctrines regarding vote dilution claims, most notably in a major companion dispute originating from the state of Louisiana, titled Louisiana v. Calais. In the Calais decision, the High Court established a much stricter, highly rigorous analytical framework for evaluating Section 2 claims, emphasizing that lower federal courts must carefully separate race from partisan politics, grant substantial judicial deference to legitimate state redistricting objectives, and avoid treating ordinary political disagreements as automatic proof of unlawful racial discrimination. Armed with this newly updated legal standard, the Supreme Court began vacating lower court rulings across the country and sending complex redistricting disputes back down to regional benches for fresh evaluation. This included Alabama's ongoing saga, where state officials argued with mounting frustration that the entire legal landscape had fundamentally shifted right beneath their feet. According to Alabama leaders, the federal district court charged with reviewing their revised maps completely ignored the High Court's fresh directives, choosing instead to repeat the exact same legal errors that had already been invalidated by the highest court in the land. The friction between the state and the lower federal bench intensified rapidly as election deadlines loomed closer on the calendar, threatening chaos for election administrators and voters alike. Facing another court-ordered alternative map that was drafted and imposed by the judiciary rather than elected lawmakers, Alabama officials took aggressive, decisive action to defend their legislative authority. They marched straight back to the Supreme Court, seeking immediate emergency relief in the form of a formal stay. In a decisive emergency order, the High Court granted Alabama's request, halting the lower court's restrictive injunction and instantly restoring the state-preferred congressional map for the upcoming election cycle. But the majority's written opinion accompanying that emergency stay went far beyond a temporary procedural pause or a routine docket management decision. The Supreme Court explicitly concluded that Alabama had demonstrated a strong likelihood of prevailing on the merits of the case down the road, signaling a profound, unmistakable rebuke of the lower court's handling of the litigation. The justices noted specifically that the lower court had failed to presume that state legislators acted in good faith, improperly dismissed non-racial geographic objectives, and relied on alternative plaintiff-drawn maps that completely ignored the state's traditional redistricting criteria. Rather than stopping there and wading through years of predictable appellate delays in the United States Court of Appeals for the 11th Circuit, Alabama's seasoned legal team launched a rare and aggressive procedural maneuver designed to force a definitive resolution. The state officially filed a petition for a writ of certiorari before judgment, asking the Supreme Court to entirely bypass the 11th Circuit and take up the case for a full merits review right then and there. This bold move was engineered to force a permanent nationwide settlement of the complex legal questions plaguing election administrators and state lawmakers across the country. In its detailed petition, Alabama argued that further proceedings before the Intermediate Appellate Court were completely unnecessary, because the Supreme Court had already provided a clear binding constitutional framework in the Calais decision. The state's legal brief underscored that its 2023 congressional map was meticulously crafted to advance legitimate, non-racial state objectives, such as preserving distinct Gulf Coast communities of interest, keeping vital geographic regions intact within single districts, protecting incumbent representatives from forced pairings, and minimizing the overt dominance of race in boundary drawing decisions. The implications of this aggressive legal strategy extended far beyond the geographic borders of Alabama, capturing the intense attention of constitutional scholars, political strategists, and state election officials nationwide. At its core, the high-stakes dispute forced the Supreme Court to confront fundamental questions regarding the delicate balance of power in American federalism. How much deference do federal courts actually owe to sovereign state legislatures when drawing political maps? Where is the exact legal boundary dividing permissible race-conscious remedies from unconstitutional racial gerrymandering under the Equal Protection Clause? And under what precise circumstances can federal judges step in to override a state's sovereign election laws without violating constitutional norms? By asking the Supreme Court to fast-track its review, Alabama positioned itself squarely at the vanguard of a broader conservative legal movement seeking to roll back aggressive judicial interventions in state election administration. The High Court's willingness to engage with this petition and evaluate the evolving Calais standards send an undeniable shockwave through the legal establishment, proving once again that the rules governing political representation in America are undergoing a permanent and historic transformation. As legal analysts pore over the administrative filings, a deeper picture emerges regarding how future election cycles will be governed. The petition itself, filed by Alabama Attorney General's office and supported by legal scholars specializing in election law, details a compelling narrative of judicial overreach. The core argument rests on the premise that when the Supreme Court hands down a definitive interpretation of federal statutes like the Voting Rights Act, lower courts do not possess the discretionary latitude to reinterpret those mandates through a lens of skepticism towards state legislatures. The brief highlights specific instances where the three-judge district court panel allegedly disregarded the legislative record compiled during the special session, where lawmakers debated various map configurations. During those legislative sessions, lawmakers emphasized economic connectivity along the state's southern tier, maritime trade dependencies, and regional transportation corridors as primary driving factors behind the map's geometry. Yet, according to the state's filings, the district court dismissed these economic justifications as mere pretext, substituting its own aesthetic and demographic preferences for the considered judgment of elected representatives. This analytical divergence brings into sharp relief the tension between quantitative demographic metrics and qualitative community identity. Challengers argued that the state's geographic configuration systematically suppressed minority voting potential by packing and cracking demographic groups across district lines. Conversely, the state maintained that any map attempting to satisfy the plaintiff's demands would inherently require subordinating traditional race-neutral districting principles such as compactness, contiguity, and the preservation of political subdivisions to the single overriding objective of race maximization. The Supreme Court's ruling in Allen v. Milligan had found fault with Alabama's previous map, precisely because it failed to provide an additional opportunity district under specific factual findings. However, when Alabama returned to the drawing board, state mapmakers argued they had structured a new map that respected the core holdings of Milligan while navigating the emerging boundaries set by subsequent jurisprudence. The refusal of the lower court to accept the state's subsequent adjustments ignited the current procedural showdown, forcing the highest court in the land to clarify whether its precedents are being faithfully executed across the federal judiciary. Furthermore, the decision to seek a writ of certiorari before judgment introduces fascinating dynamics into appellate litigation strategy. Typically, appellate filtering through circuits like the 11th Circuit allows legal issues to percolate, giving multiple judges an opportunity to weigh in before the nation's highest tribunal takes up a controversy. However, when a lower court is perceived by a litigant as openly defying or misapplying controlling high court doctrine, percolation gives way to crisis management. State election administrators across the country are facing mounting pressure to finalize precinct lines, print ballots, and program voting machines ahead of upcoming primary and general elections. Uncertainty breeds legal instability, which can disenfranchise voters and erode public trust in electoral outcomes. By petitioning for immediate review, Alabama is effectively arguing that the cost of delay, measured in judicial confusion and administrative chaos, far outweighs the traditional benefits of appellate percolation. If the Supreme Court agrees to hear the case directly, it will signal a zero-tolerance approach toward lower court non-compliance with newly established voting rights frameworks. The potential ripple effects of this case extend to numerous other states currently embroiled in redistricting litigation, including Georgia, Texas, North Carolina, and Louisiana. Each of these jurisdictions has faced its own protracted battles over legislative and congressional boundaries, with federal judges issuing conflicting rulings on the proper application of Section 2. A definitive ruling from the Supreme Court on the exact evidentiary burdens required to prove vote dilution, as well as the permissible scope of state legislative discretion, would provide an indispensable national compass. Legal practitioners on both sides of the aisle are watching every docket entry with bated breath, knowing that the outcome will dictate campaign strategies and candidate viability for years to come. The intersection of statutory interpretation, constitutional command, and judicial federalism has rarely been so volatile or so consequential. As election calendars continue to press forward and legal teams prepare their final arguments, the eyes of the entire legal community remain locked on Washington. The decisions made in this ongoing battle will not only determine the immediate political landscape of Alabama for the upcoming decade, but will also establish a binding national precedent that will shape how millions of Americans experience their democratic rights. The intersection of federal voting statutes, state legislative authority, and judicial oversight has created a labyrinth of constitutional questions that demands ultimate clarity from the highest court in the nation. With responses filed, briefs submitted, and the Supreme Court weighing its next historic moves, the final chapter of this redistricting saga is poised to redefine the limits of judicial power in American elections. That's it for today, folks. See you in the next video.